All right, I'll go along with what probation is now recommending, but I'm gonna let you know. Um, Ms. Polera gives people a chance that's consistent with how this court feels. If you mess this up, I'm not going to be because the final decision is mine. I'm not going to at all be listening to any kind of break for it. You will just do time.
Good morning, Mayor. Please, the court attorney Damien Cash, P number 85852 on behalf of Mr. Taylor Byer. Mr. Byer, state your name for the record.
Taylor Mer, Byer, Your Honor.
All right, date and time for sentencing. Have you reviewed the report?
Your Honor, yes, we've reviewed the PSI report. I have no additions or changes or deletions, Your Honor. I just do at some point want to discuss the bond violation that Mr. Byer had in the report that I recently received.
Well, go ahead.
So, Mr. Byer, I called records at Bear River Treatment Facility in roundabout Traverse City area. He was admitted for treatment on November 24th. That is the reasons and the explanation for why he was not able to test. I do understand that he was in contact with, at times, the probation department to inform them that he was in treatment. I'm not exactly sure how those conversations detailed. However, he was in treatment. He completed December 23rd, and they confirmed the records to me this morning, and I also reported those records to your court as well, Your Honor.
He completed Bear River.
He completed Bear River, yes, Your Honor.
I think I'm not going to find a violation because I think that the issue is potentially that there wasn't a release information. It wasn't anything that this gentleman did. I was a circumstance where information was just not flowing
Back and forth.
yes, like it should have been. So I'm not going to find a violation of that.
Thank you, Your Honor.
Doesn't seem to be a violation. He's in treatment. So, all right.
He owed him some flowers and candy as I promised him this morning for his record.
Okay. Okay. Anything else?
Other than I'll just briefly allocute. I've been in contact with his family, his brother, and they informed me along his siblings. They are, I would say, very interested in seeing his growth and his continued development as he continues to go through treatment. I believe it is very serious to him as well, as he's admitted to himself. He's explained to me multiple times that it is very serious to him to get through this treatment process to better himself, and that really he just want to get back to being a productive citizen and back to work, Your Honor.
Yes, Your Honor. Sir, anything you want to tell me?
I want to say thank you for everything you did, because it actually helped me in my life to get my life on track. And I only want to do the right thing. I want to be the best dad I can be for my son. And I just want to be the best person I can be. And I just want to say thank you for helping me with my journey, because I'm on the right path. And I just want to say thank you.
You're welcome, sir.
Thank you.
Ms. Blair, just so that I can make sure I'm understanding this, the proof of treatment.
Your Honor, I was not able to
Fair.
obtain that information because there was no release of information.
Got it.
However, it was brought to my attention when Mr. Byer was arraigned that he advised the court that he was in treatment,
And
they had something of attendance but no completion. So I know he represented that he did complete it. I just was not able to.
right, and I think,
Can I say something?
was this the one that we received that indicated that? Or was that another one? Was another one. Okay. I guess I don't have the proof of the treatment yet. myself, but
Last week when I was here, I gave my completion to Judge Reese, and I actually have my completion in my file.
you gave it to who?
Judge Reese, is that her name?
Well, we don't have a Judge Reese.
Oh. I gave her the copy last week and they made a copy of it. It's actually in my folder.
I was to say, that's from Bear River.
Yes.
The records I received today will be the most, I'll say, up to date records that was released this morning, Your Honor. And hopefully that is enough to, because it states on there.
Yes, they
testimony.
Well, which records are you talking about? I actually have it. I see the verification of the discharge letter from Bear River. I see it now.
Okay.
Indicating that he has successfully completed the program.
Okay.
So I have it. I see it. It was one of the other papers that was on there. Okay. And that's the treatment you were talking
Correct.
about. Okay. Very good. All right.
Your Honor.
You're welcome. So I will sentence of the court, $125 statutory fee. I'll order 90 days in jail, credit 61 that he served. The balance of that is suspended.
Thank you, Your Honor.
Okay, so I'm changing that. Good luck to you, sir.
Thank you, sir, and you have a wonderful day. Thank you.
Thank you.
Thank you. Oh, yes, I will, of course. I will not.
Court calls the case, People versus Wayne Ranken.
Carolyn Foster talking on behalf of Ranken. Can you state your name?
Your name? Wayne Ranken. All right, go ahead.
And Your Honor, we have had a chance to review the pre-sentence report. We have no additions, corrections, or deletions. We would ask the court to follow the recommendation. Mr. Rankin did indicate that he needs a payment plan for the restitution and the fines and costs. He said he can make a payment by Friday
Yes.
of 200.
Yeah.
And then he believes he should be able to do $200 monthly payments. Is that right?
Yes, ma'am. Anything you want to say, sir, before I impose sentence?
Just no, I don't really have much. I just take full accountability for my actions. Just made a bad error in judgment at the time. I just got back to working for a Bill property. I was laid off, so that's why I'm not being able to pay anything today.
Sentence of the court, $400 fines and costs, $3,484.87 restitution to the victim in this case payable through the court. I'll order 93 days suspended. As to the payment of the fines and costs and restitution, that's to be $200 per month beginning January 16, 2026. I will set a review hearing that will be June 10th, 2026 at 9 a.m. to verify compliance with the payment plan.
Okay.
All right.
Thank you, Your Honor.
Thank you.
Court calls the case, People versus Deanna Conrad.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Conrad. Ms. Conrad, state your name for the record, please. Deanna Conrad. Today is the date and time set for defendant today. Do ask that the court adopt the recommendation that Ms. Conrad has been in custody for quite some time. I would ask for a payment plan to be established with probation on the fines, so she can get out and get back on her feet before starting to pay those.
Anything you want to say, ma'am, before I impose sentence?
No,
And you know why you're here, right?
I do.
You got to. He's got to do stuff different,
Yes.
right? The court acknowledges this is not a serious misdemeanor as defined by statute, however, does believe there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of outpatient substance abuse treatment, attendance at AA meetings, and abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation for a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. So therefore, the sentence of the court that you are placed on 12 months probation. You're to pay $855 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs, $360 probation oversight fees. That is to be paid in a payment plan as established by probation. There is to be no use of alcohol, recreational marijuana, or illegal substances. You'll be subject to random testing as requested by probation. You're to complete outpatient treatment, including all recommended aftercare with status reports to probation. You're to provide proof of the victim's input panel attendance to probation. You're to attend 2 AA meetings per week with monthly verification to probation. You are to report to probation on January 20th, 2026 at 2 p.m. That is an in-person. Right? And then you're to report as directed. I'll order 93 days in jail, credit 47, balance is suspended. All right. Thank you.
Thank you, Your Honor.
Calls the case, People versus Rex Jenkins.
Incarcerated in a facility in Ohio. Your Honor, I do not believe he was writ for today's hearing, but I was able to meet with him and go over the recommendation, and he would be asking the court to follow it even without his presence.
All right. And so you're indicating that you wish the court to sentence him in absentia on this violation.
Yes, Your Honor, and I did speak with him directly yesterday, and he gave me permission to proceed in that manner.
All right. And so he admits to the violations of probation. In absentia, will sentence the defendant to 365 days in jail, credit 365 served. He is to pay $545 outstanding restitution balance that will be sent to our collections department. I will waive all remaining terms, discharge him from probation without approval. Thank you. Court calls case, People versus Leo Stringa. 2 cases.
Assistant Public Defender Natalie Pate, on behalf of Mr. Stringo, stands to my right. Please state your name for the record, sir.
Leo Stringer.
Thank you, Your Honor. Today is the date and time set for both cases. We have reviewed both the pre-sentence investigation reports and do not have any material corrections. And as to the recommendations for each case, we would respectfully request the court follow them.
Is there anything you want to say before the court imposes sentence?
Oh, yeah.
The case ending in 1106 sends the court $125 statutory fee, $251.80 restitution to buyers payable through the court. That will be due 60 days after release. I will order 93 days in jail, credit 62 days. The balance the defendant is due. On the other matter, that ending in 0612, $125 statutory fee, $107.94 restitution to TJ Maxx payable through the court. That will also be due 60 days after release. And then I'll order 93 days jail, credit 62, the balance he is to serve. Thank you.
Thank you.
Thank you.
Court calls case, People versus Eric Mays.
Assistant Public Defender Natalie Pate, with and on behalf of Mr. Mays, who stands to my right. Please state your name for the record, sir.
Eric Mays.
Teresa Claire on behalf of probation. Your Honor, Mr. Mays is before the court today for a violation of probation hearing. I know that the recommendation that I presented to the court today is a jail recommendation. However, I've had a chance to speak with counsel and Mr. Mays today. I would ask the court at this time, I would like to give Mr. Mays an opportunity to meet with me to provide what he has been doing. I think that treatment is a big component that Mr. Mays needs to accomplish. I would like to see where he is with that. Given that, I would ask the court to adjourn this violation hearing to February 25th, 2026, that Mr. Mays be placed on a scram tether today. My office could do the referral for that, have it sent over. And that he stay today and meet with me after I get out of court to go over and see what happens. And I would also like Mr. Mays to know on the record that he is getting a very, very big break from me. So I expect that the court order to be followed. And then we'll see where things are at the February 25th BOP.
Thank you.
Thank you, Your Honor. That is all correct that Ms. Blair stated, and I would like to thank her for this, what's the word I'm looking for? Edited recommendation. I apologize, Your Honor. And Mr. Mays is also very grateful for the opportunity to get back into compliance with this. Obviously, we have absolutely no objection to the scram tether or anything like that. We would ask the court to adopt that recommendation.
Is there anything you want to say?
Just that I looking forward to, prove to the courts that I'm on my way to my rehabilitation, that I don't want to be able to talk to my family or my workers that I have that work for me to complete the jobs that we have going, and to show that I'm a good citizen of society.
All right, I'll go along with what probation is now recommending, but I'm gonna let you know. Ms. Polera gives people a chance that's consistent with how this court feels. If you mess this up, I'm not going to be because the final decision is mine. I'm not going to at all be listening to any kind of break for it. You will just do time.
Sure.
Am I clear?
Perfectly clear.
I'll adjourn the violation of probation hearing to February 25th, 2026, 9 a.m. The defendant is ordered to meet with probation today immediately following Ms. Blair's attendance in court today. The defendant is also going to be ordered to report to community corrections for placement on a scram tether today. All right. Okay.
Thank you.
Thank you, Your Honor.
Go down to my office, that referral for the scram tether. You can go over and get it put on, and then I'll meet with you after.
Okay.
The court does call the case of People versus Legary and Thomas.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Thomas. Mr. Thomas, state your name for the record.
Gary Thomas.
Your Honor, this is the show cause hearing for money owed. When I spoke with Ms. Thomas a few days ago, we were going to ask for an adjournment. He's was in custody, he's out of custody, he's getting back on his feet. However, now that he's back in custody, he's obviously not working. So I just asked to set this out.
Well, I think what I'm going to do is I'll just refer this to collections rather than bring it back and forth. So our collections department to deal with it.
Thank you, Your Honor. Mr. Thomas was asking what his bond is on this case, if the court has it.
Should be possible.
I believe it was a PR.
Well, no.
He posted them. So. 1,000.
Posted 100. Now, his bond was denied. Then, yeah, so his bond was actually 10,000, 10% on April 30th. Then on September 22nd, 2025, the magistrate lowered it to 1,000, 10%, which he posted.
Okay, so he's not being held on this case then. All right.
Thank you, Your Honor.
Thank you. Court calls the case People versus Larry Evans.
Natalie, hey, Mr. Evans. Your Honor, Mr. Evans has been actively texting me. He is on the bus and he was going to appear on Zoom today. He's been texting me since 8:30, trying to get on Zoom in about an hour.
He's on a bus?
He is. And
Where?
I look at like, oh, literally just now, I'm in the building. Sorry. But 14 minutes ago.
So I can't issue a bench warrant?
No. Yeah, because.
He's in the building? Like where? Where?
I can go.
This is a big building.
It is. He's probably either about to go through security or just did. And I will say,
You're doing that Nebo look toward the door, hoping that he's gonna walk through at any moment.
I hope so, but I believe him. I will say this.
You do believe him?
Yes, Mr. Evans has never lied to me. He's talked to me a lot. So, never lied to me yet. This would be a weird first lie. Because I can so easily prove him
I don't
wrong.
think he's in the building.
I will text him. Hurry. Hurry.
Where? He's in the building. I'll pass it.
Thank you so much, Your Honor. I do appreciate it. Did it yesterday too, was prepared to see.
Court calls case People versus Carlos Mack. Say again. Oh, okay. Oh, here she is. Ms. Rushing,
Judge.
good morning. You want to state your appearance?
Yes, Judge, can you hear me?
Yes, I can hear you.
Okay. Looks like I was having some connection issues. I apologize. Your Honor, Sydney Rushing, appearing on behalf of Mr. Mack this morning. And I'm standing in for his attorney of record, Mr. Bird. Mr. Mack, is that okay with you?
Yes, ma'am.
All right, state your name.
Carlos Mack.
And can you state your name for the record? Oh,
We got that. I have here that an alcohol screening assessment was completed and defendant is currently being held with no bond because of his sober link violation.
that is correct, Your Honor. It's my understanding that to complete his assessment, he cannot do the portion that he has to complete yet in the custody. I believe that there is a request and agreement to allow him to be released on a scram tether so that assessment can take place and that his sentencing can proceed forward at the next date.
All right. Okay. I will allow the defendant to be released from custody with a scram tether that must be fitted on the defendant prior to release. Ms. Blair, were you going to do that referral or did you want to?
I can do it, Your Honor, if you'd like, or,
Ann already
She's got
got it. All right. And that will be prior to release. Defendant is then referred to Von Swartz for an alcohol screening and assessment. And the sentence in this case will be adjourned to February 11th, 2026 at 9 a.m. Thank you.
Thank you so much, Judge. Happy New Year.
All right. Yes, and to you. My staff was just saying that you're one of their favorites. I can't say I have.
Well, they're my favorite, so it's mutual.
And that they said that they hadn't seen you.
And Judge, I might not be your favorite, but you're one of my favorites too. So I'll put that out there for you.
I didn't say you weren't. I just said, all right, very good. Okay, great seeing you. Take care. I don't know if he has that. I have to set his bond at a PR. It was denied. It's being held on because it's a violation.
So you want to be here?
A PR. Court calls the case, People versus Jessica Lopez.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Ms. Lopez. Ms. Lopez, please give your name to the record.
Jessica Lopez.
All right.
Teresa Claire on behalf of probation. Your Honor, Ms. Lopez is before the court for a review hearing on a prosecutor deferred sentence. Ms. Lopez has had some struggle financially. Her family's been helping her out with her rent and things like that. She has not paid the monies in this case. She did complete the theft class, however, and is working on the community service hours. Ms. Lopez also has, a child that she's trying to take care of, and she is working. Given all of the circumstances with Ms. Lopez, probation is recommending that the court extend this prosecutor deferred sentence for a period of 6 months, that Ms. Lopez make $100 payment by January 30th, 2026, then $100 per month thereafter, that all other conditions continue, with a next review hearing being set July 8th, 2026 at 9 a.m.
All right. Ms. Lopez, can you make that payment by the 30th?
Yes, actually, my brother's been helping me with a lot of my bills. As this is actually helping me a lot. He's helping me with a lot of things, so I stay on track and not do any mistakes again like this. It's just really hard. I'm a single mother, and he said he's willing to help me with anything I need. So as long as I continue working, it's so.
Being one myself, brothers are good people. What I'm
Yeah.
going to do is I will extend the prosecutor's deferred sentence for a period of 6 months. You're to pay $100 by January 30th, 2026, and $100 per month thereafter. I'll continue all other terms as previously ordered. I'll set a review hearing for July 8th, 2026 at 9 a.m. All right, Ms.
Yes,
Lopez.
sir.
All
Thank you
right,
so
good luck
much.
to you.
Thank
You're
you so
welcome.
much. Bye-bye.
Court calls case People versus Christopher Mary.
Teresa Claire on behalf of probation. Your Honor, Mr. Mary was scheduled for a review hearing on a prosecutor deferred sentence. He did complete all terms ordered by the court, and he did waive his return. Probation is recommending that the court dismiss the case pursuant to the prosecutor deferred and discharge him from probation with improvement.
The courtroom goes silent. Every eye turns forward as the tension thickens in the air. One mistake, one excuse, one wrong answer, and everything can change in seconds. This isn't just about laws or paperwork anymore. This is about accountability, consequences, and a moment that will follow someone long after today ends. The judge listens carefully because justice isn't rushed, but it is inevitable.